I'm Jenny Lauren Dowden for Conduit News. Today we have Joey McCutchen joining us. He's an attorney in Fort Smith. He's also the co-founder of the Arkansas Transparency and Government Group. Joey has tried many FOIA cases all the way up to the appellate courts. He's here today to talk to us about his concerns regarding the Sunshine Law here in Arkansas. Joey, thanks for joining us.
Thanks for having me. I think this is a very important session.
Absolutely. You have testified countless times in committees over the years down in the Capitol, most recently during the regular session and then the special session. Talk to us about your concerns coming out of those two sessions.
Well, I think concerns in both of those sessions is that there's a tendency by the legislatures to disrespect our FOIA law and to gut our FOIA law, particularly open meetings and open records. And that leads us squarely to this constitutional amendment, which will and should forever protect transparency and open government in Arkansas. And we have a brilliant opportunity, but the devil's in the details. And if we don't get it right out of the gates, if we don't get it right in this initial draft, we're going to lose a lot of people, because this needs to truly be the people's law. And we can discuss, particularly in terms of open meetings, which I think that's what the people care about. They want their governing board members to do their business in public, not in private email chains, text message chains, and in the back of McDonald's.
I think that, during the regular session, we saw bipartisan opposition to a bill that directly addressed this. And as you talked about open meetings, the FOIA law deals with half of that. And right now there's a discussion about that's happening on the state level dealing with government transparency. And a lot of that deals with emails, text messages. Would we even see that if, say, we had a clear definition or a not so clear definition of what open meetings and transparency would look like? So give us a definition of a meeting. What would that look like?
Well, in my opinion, and in the people I've talked to, and I have gone around this state for years talking to people about what an open meeting is. And they're confused because, number one, the appellate courts have on a piecemeal basis, have decided case after case. So they want a definition. Both citizens want a definition, and governing bodies like school boards, city councils, forum courts, they want a definition. And the definition that I've seen that they liked, and my expectation, if we're going to put the right to know FOIA in our Constitution, a definition that's for the people, regnant populace, should look like this. If you have a gathering of 2 or more members of the governing body and they're discussing public business, that's a meeting. And that discussion should occur in open board meetings where you and I have the opportunity to hear the sausage being made and the final result. So a meeting, just like it's a meeting of 2 people, whether that's on an email chain, a text message chain, or in the back of McDonald's, when they're discussing public business, which is likely or foreseeable to, there's going to be a foreseeable action in the future at a board meeting, then that should be public. Now, I have, as recently as this morning, I've had discussions with some folks, some drafters, and they're like, well, what about if 2 members of the Newport school board want to meet? Well, that's why I'm expecting language that covers that. What's called chance encounters. If two of these board members meet at the local McDonald's or at a Friday night football game, then there's going to be language that's not a meeting. A chance encounter to talk about burgers or basketball or the Hogs is not a meeting. That language should be in there and clearly spelled out. And we've also heard, I'm also for for an exception that on-site inspections of a highway project, if let's just say the quorum court wants to go out to a highway project, or they have a school program, let that be an exception, and that language should be in. That would not be a meeting. But these board members would clearly know that you cannot use that opportunity, whether meeting at McDonald's to talk about their Friday night football team, or going out to a project, or going to a program at school. They can't use that opportunity to violate the intent of FOIA, which is, if you're going to have discussions of public business that's going to be voted on later, that it be done in a public forum where you and I and everyone else can see that discussion. How could anybody be against that, other than folks who want to violate FOIA, who are serving on school boards, and they want to have, there's going to be people who have secret meetings, but this definition that when two or more folks are governing body, the members of the governing body are discussing public business, it must be done. Notice must be given to the media, and the public sees all the discussions.
We saw a lot of legislators and a lot, like you mentioned, a lot of school board members and other officials really wrestle with this during the regular session, and help us understand why that would be. Why would you have, if you are an elected official, you were voted in by your constituents, by those, whether it be in your district, in your town, whatever it may be. Why do you have a problem if you were voted in? Why do you have a problem with your business being out in the open, and for them to be able to see what's going on? I don't understand it.
Yeah, and you know, under a well-crafted FOIA bill that says chance encounters, if you go to eat with your you know,
a school concert or something, that doesn't count.
Yeah, there should be no concern. You know, there's also been, someone said, well, what about violating the First Amendment rights of these school board members? Well, we're not violating anyone's rights. They can, two school board members can go out and talk as much as they want to about the hogs, about anything, that just not public business. And then they can discuss public business as much as they want in the public meeting. And what that does, that creates trust in government. But we've all seen it. When you go to a board meeting, a quorum court meeting for a multi-million-dollar project, and you never see any discussion, you just see the votes, you know that those discussions have been had in secret. So let me just say this, the drafters of this bill, if they take their time, they can create a bill that the people will get behind, and two or more discussing public business. Now, you can't say, well, you know, they never made a decision. I mean, how are you going to determine if you and we meet together and we just have a discussion? You're going to know how I feel. I'm going to know how you feel. So you can't go, well, they have to make a decision. No, they cannot discuss or deliberate our public business down at the local McDonald's or on secret email chains or text message chains. And I think the people will get behind that. Now I'm giving the benefit of the doubt to the drafters and this so-called coalition that's out there. Now, we had a coalition in the special session. We had organically left, right, Democrat, Republicans in unison speaking against those horrendous bills that gutted open records and open meetings in the regular session. But that coalition will fall apart because really quickly, if this isn't a people's law, if we're going to put this in our Constitution right next to our Declaration of Rights, we're going to put the right to know in our Constitution, then it needs to be the people's law. And if you start doing a Mary Bentley bill, which allows 1/3 of our quorum court members to meet in secret, that does not need to be in our Constitution or anything close to that. This needs to be a open meeting definition that people are going to say, now this is the strongest open meeting law in the country, or else save your millions of dollars. You know, don't bring in these folks that are these transparency groups that are willing to give millions of dollars to get this thing through, if we're going to have a watered down version that would pass through the legislature. This is a people's bill, not a legislator's bill, not a government bill, but a people's bill. And if we don't see that on the initial draft, I cannot support it, and I will not support it. It's got to be very, very well drafted. And hey, let's I've heard comments from government folks on just what we've talked about, that, well, I'm scared to meet to go to lunch with one of my co-members of the governing body. They won't be if this bill's well crafted, because they're going to include chance encounters in that, just like Tennessee's done. You know, and again, I heard during the legislature, well, what if the quorum court members want to go out to a road project? Well, let them go, you know, and that should be, we've drafted language. Robert Steinbuck and I have spent hours upon hours, weeks upon weeks, crafting a bill that they don't have to do much crafting, because this is a people's bill that we've worked on.
Yeah, talk to us. I mean, do you think that if they did not include language like that, do you think it would have the people's support? And even, you know, like I mentioned, when that bill by Mary Bentley was in the regular session, it had bipartisan opposition. You had the press come out against it. Do you think that if it did not include language that gave that definition of a meeting, if it allowed them to meet like that, do you think that it would get through?
No. I think the people, if they're going to put it in our Constitution, they want this to be transparent, open government friendly, and people friendly. Something we can be proud to call the people's law. And I think the coalition will fall, you know, because, I mean, look, this protects liberals. A strict definition of, if two or more members are discussing public business, which is likely to come before the governing body, you know, liberals will embrace that. Conservatives will embrace that. Freedom-loving people at the bottom line. That's why we had such a coalition when our governor, you know, ran this bill, which would have gutted open records. That's why those people came together. And if you start letting governing bodies meet in secret and give them an excuse to, and put it in our Constitution, people will vote against that. And that coalition of people, that's the coalition. I mean, I don't know what coalition they're referring to when I see the word coalition, but it's not a coalition of a bunch of bureaucrats and self-serving politicians. It quite frankly is a coalition of people that's going to pass this. I mean, that's why we're bringing it before the people. And I know that I was a co-founder of various transparency and government groups across this state. We have chapters across this state. We will not embrace a bill that waters down FOIA and gives local government the ability to do their business and our public business in secret. And it'll fall apart as quickly as it came together.
Well, what would you suggest to Arkansans who are watching this, who care deeply about this issue and want to see what you mentioned regarding open meetings for that language to be included?
Yeah, I would encourage them to when this first draft comes out, that they comment on this draft and insist that it be about transparency and open government, and that there is, for example, on the open meeting side, that they have a very strict definition that you and I can understand, that government can understand, but it complies with the intent of the 1967 law, which says it is vital to a democratic society that public business be performed in an open and public manner, so that the electors shall be advised of the performance of their public officials. And if it doesn't meet that standard, then we should not have it. And the only definition that meets that standard is that if two or more members of the governing body are talking about our public business, they do it in a public meeting, not down at the local McDonald's. But we do create a clear bill that says if you go to the McDonald's to have a discussion about how good their burgers are, you can do that. And you can talk about your you know, you can talk about anything you want to other than public business that's foreseeable to come before the public body. And that protects them. See, and any well-meaning, ethical public servant is not going to have a problem with that. They're not going to have a problem with Joey McCutchen seeing them down at the local McDonald's, because I know they're doing the right thing and they're going to comply with the spirit of FOIA. And they're going to talk about private things, but not public things that are foreseeable to come before the body.
Yeah, just while you were talking about this, the thought that I had over and over was, if you don't want to be a public servant, go into the private sector. If you don't want people to see the work that you're doing as a public servant, go into the private business. I don't understand it.
Yeah, you know, I've heard elected officials talk about their First Amendment rights to free speech, and I've heard lawyers for government bodies make that argument. Well, hey, we're not taking away your First Amendment rights, but if you don't, you can talk as much about public business in a public meeting as you want to. Private things, you can talk as much as you want to, and if you don't like that restriction on your freedom, so that I can see how much money's being spent here, or I can see what public policy is being made here, then you hit the nail on the head, Jenny.
No one forced you to run for office.
Don't run for office.
Right.
You know, you shouldn't be scared that I'm going to walk up and hear you talking at the McDonald's, because you're going to be talking about, you know, your kids and
that's right.
You know, the Razorbacks and the Friday night game tonight, and we're going to make that, or at least the drafters. I'm not one of the drafters, but the drafters should make that very clear in here, and they've got a model, because Robert Steinbuck, who I consider to be the FOIA expert and guru in the state of Arkansas, has drafted a very tight open meetings bill. And you know, and then let's not forget about the open records also. As I understand it, they're going to make, if they want to exempt records from disclosure, then they're going to have some hurdles to go over. They just can't exempt records that are our records. And I think the other thing that I'm expecting in this bill is that they are going to make it where they cannot increase the number of days, which is currently 3 working days or less. That should stay the same, because we want our records timely.
Yeah.
And if they can't be produced timely, then we always have an informal agreement. Sure, I'll give you 5 days. I'll give you a week. You need 2 weeks. Okay, I can do that. And we should never have to pay for government records. And that should be.
I was going to ask you about that. I still hear rumblings about there being maybe down the road in 2025, if not before then, because there's this weaponization of FOIA. You know, we saw with David Ray's bill, potentially, you know, if someone weaponizes FOIA, you know, requiring a fee for those documents.
Well, number one, the 99.9% of the population doesn't weaponize FOIA. That's another politician term that they're using to try to gut FOIA. You know, deal with the bad apples, get the smart lawyers together and create a limited exception for those bad actors who are requesting records that they really don't want or need. Deal with them, but don't throw the baby out with the bathwater. Yeah. And don't try to gut FOIA and call it weaponization when you've got a few rogue individuals out there who are trying to abuse the law. Don't take away my rights, because bottom line, Jenny, this is about rights. This is about our rights. And if we're going to put the right to know in our state constitution, along with the right to trial by jury, the right to bear arms, which is in our state constitution, then make it strong, just like those rights are. Don't water it down. Don't start talking to the bureaucrats. Don't start bringing in former politicians and current politicians to water this thing down. Otherwise, just don't do a sham process. You know, don't spend millions of dollars to put this in our constitution, because the people ain't going to buy it. Because there's going to be people like me. I'm going to go speak to every one way or another, if this gets on the ballot, I'm going to be speaking to every person that will listen to me. And if it's a good bill, then I'll be speaking positively about it. If it's not a bill, if it's a bad amendment, I'll be speaking negatively about it. And by good and bad, I mean, does it meet the legislative intent? And does it belong next to Article 2, our Declaration of Rights in our Constitution? Because I'll tell you this, we have littered our Constitution with a bunch of trash through constitutional amendments and otherwise that should not be in our Constitution. And this is something that should be in our Constitution. It's one of our most important rights. If we don't know what the government is doing, then we are going to lose our rights. And this is the people's law. And the drafters of this constitutional amendment and those involved with it, at least I've tried to make them understand. Get on their Facebook page.
It's an open Facebook
comments.
group. Yeah.
Yeah.
All right, Joey, great insight as always. We really appreciate you joining Conduit. I hope to talk to you again soon.
Thank you. Look forward to it.